everyone, welcome back to a brand new video. And again, I'm using new sparingly. If you were there for it, this is actually a remake of an older video. And the topic today is actually how international law threatens the United States Constitution and our civil liberties. So make sure to drop a like, subscribe, and let's get into the topic. Alrighty, ladies and gentlemen, here we are at the presentation. So to understand how international law actually threatens our civil liberties, we have to look at an old case, and that is of Missouri v. Holland from 1920. So to give you a little bit of background, this was a case where Congress had tried to regulate the hunting of migratory birds, claiming it was their jurisdiction to do so, and that claim was based on the fact that they're migratory. They cross international borders, they cross state lines. So therefore, instead of letting local governments or state governments regulate the hunting of these birds, the federal government stepped in and said, hey, that's actually our jurisdiction. But states actually weren't happy about this, and states successfully contested the constitutionality of these laws through the 10th Amendment. Now, the 10th Amendment actually states that power is not enumerated to the federal government, so power is not given to the federal government, and not prohibited to the states were powers of the states. Now, I actually have a video that's about to come out about the 10th Amendment, the Civil War, and secession. So if you want to know more about that topic, please watch that video. But to explain how that amendment applies to this case, essentially, the state said, hey, since the Constitution doesn't explicitly state that you have jurisdiction in this case or the power to regulate this issue, and because that power is not specifically forbidden to us, this is a state issue. This is not a federal issue. It is up to the states to regulate the hunting of these birds. The federal government has no say here, and that argument was actually successful. The states were able to challenge the constitutionality of legislation passed by Congress under the 10th Amendment and be successful about it. And Congress wasn't happy about that. So what do? Well, they actually find a loophole. So disgruntled that they could not regulate these birds, Congress saw a workaround. In Article 2 of the United States Constitution states that the president shall have power by and with advice and consent of the Senate to make treaties. So Congress and the president enacted a treaty with Canada, which was actually the United Kingdom at the time, because if you know, in 1920, Canada was not a fully independent sovereign country. So we actually did our negotiations and diplomacy with the United Kingdom and recreated this treaty called the Migratory Bird Treaty. And some treaties are self-executing and some treaties are non-self-executing. So what it means for a treaty to be non-self-executing is that additional legislation is needed to effectively enforce that treaty. So Congress had to pass the Migratory Bird Treaty Act of 1918 to enforce this treaty that we entered into with the UK and Canada. So let's take a look at the case. So the state of Missouri actually challenged that act under the 10th Amendment. So the state of Missouri challenged its constitutionality, and the Supreme Court actually found the act to be constitutional under the supremacy clause. Now, what's the supremacy clause? You may or may not be asking. Probably not, because you learned this in 7th grade civics. Well, the supremacy clause, located in Article 6 of the U.S. Constitution, states that federal laws and treaties made by the federal government are the supreme law of the land. So federal law trumps state law. I mean, this is basically Civics 101. You probably understand this. But what a lot of people don't realize is that the supremacy clause includes treaties too. So treaties technically trump state law. And Justice Oliver Wendell Holmes actually wrote the majority opinion in this case. And in that opinion, he actually opines a very dangerous legal interpretation doctrine, and that is the doctrine of living constitutionalism or legal pragmatism. And to explain exactly what living constitutionalism is it's the belief that the United States Constitution evolves with time and changes its meanings without the need of amendments. So to explain exactly what that means, let's talk about the First and Second Amendment. So if you're active in any political sphere, you've heard people say that, oh, The founding fathers didn't know that one day we'd have mass communication, or that one day we'd have social media or television. So therefore, we need to limit the First Amendment because the founding fathers did not foresee the technology that we have now. That argument, which I do not support, by the way, would be a form of living constitutionalism. It's people who believe that the Constitution's interpretation should change over time to fit society's needs. Now, I am of the belief that the Constitution is a timeless document. So I don't believe any of this, and I think it's actually a very dangerous interpretation doctrine. But proponents of living constitutionalism also apply the same arguments to the Second Amendment. You've definitely heard these before. People who say that, the founding fathers did not foresee assault rifles. They did not know that one day we'd have fully automatic rifles and AR-15s. So therefore, we need to limit the Second Amendment. That argument, which again I don't support, is a form of living constitutionalism. And of course, Justice Holmes pioneered this idea in his opinion, his majority opinion for Missouri v. Holland. And one thing I have up on screen here is a little bit of an excerpt from that opinion. So I'm going to go ahead and read it because it actually describes the idea of living constitutionalism. And try to follow along, but if you can't, it's not that big of a deal. It doesn't matter that much. So he states, with regard to that, we may add that when we are dealing with words that are also a constituent act, like the Constitution of the United States, we must realize that they have called into life a being, the development of which could not have been foreseen completely by the most gifted of its begetters. So again, that describes the idea of living constitutionalism. So we have to ask, was the ruling in Missouri v. Holland a dangerous ruling? And of course, I argue yes. That's the whole point of this video. So, international treaties can be used to increase the powers and jurisdiction of the federal government and can be hypothetically used to pass laws that conflict with the Constitution. And another one of the problems with the ruling of this case was that treaties potentially now give foreign nations a way to threaten American civil liberties. And the worst that happened in Missouri v. Holland was Canada and the UK got the enforcement of their Migratory Bird Hunting Act. But as you saw, that treaty and the act that was subsequently passed to execute that treaty actually gave Congress power that it didn't possess beforehand because of the 10th Amendment. So think of a scenario where a foreign nation effectively forces us into a treaty and how that treaty could give Congress the power to violate any one of our constitutional amendments or civil liberties. And again, this was also a dangerous ruling because of the birth of the legal interpretation doctrine of living constitutionalism. And I have here up on screen, I will definitely make a separate video on living constitutionalism versus originalism at some point, because that's one of the biggest legal debates that's ever existed. So, to continue, what's the solution to this problem? Well, something called a Bricker Amendment has been proposed in the past, and that's actually named for Senator John W. Bricker, who was the sponsor of this proposed amendment. And several versions of this proposed amendment have actually existed, but the most famous one, proposed in 1953, actually only fell one vote short, I'm pretty sure. But that version wanted to ensure that no treaty that conflicted with the Constitution could ever be adopted, and to ensure that no treaties could give Congress powers that were not listed in the Constitution. Now, I believe that a Bricker Amendment along those lines is essential to safeguard our civil liberties from foreign interference and to restrict federal tyranny, because the case of Missouri v. Holland has clearly demonstrated how treaties can be used to go around constitutional limits and how treaties can be used to give Congress powers that it simply didn't have before. So ultimately, this amendment that has been proposed is one solution to the problem that has arisen because of the decision in Missouri v. Holland. And my final thoughts are obviously that Missouri v. Holland greatly expanded the powers of the federal government. And now, especially being in an era of internationalism and globalism, the need for a Bricker Amendment to safeguard our Constitution and system of government from federal tyranny has only grown. And treaties potentially being able to violate the Constitution definitely opens us up to foreign interference, and it's a very dangerous power for Congress to have. And we definitely need some kind of safeguard in place to make sure that that can't ever happen. And as such, like I've stated, with the Bricker Amendment, we need to limit the treaty powers laid out in Article 2 of the United States Constitution. So guys, thank you for watching that video, and if you could please like and subscribe, I'd greatly appreciate it. I'm still a brand new channel trying to grow, trying to fight the algorithm, so every single thing you guys do for me helps, and I hope you guys have a great day, and please put any comments, suggestions, ideas, anything down below. Thank you.